Hi, so welcome to the first substantive lecture for week 2. So I'm calling this topic 2.1 because in topic in topic 2 we start this week with the soft law instruments and we move next week to the hard law instruments. And in this topic 2.1 we're going to deal with international commercial contracts. And clearly that's the whole of the topic 2, and we're going to deal with the UNIDROIT is how I tend to say it in my head, the UNIDROIT Principles, and we're going to talk about the Incoterms, and I'm really embarrassed that I don't have closed parentheses on that slide, but hey, I'll be fixing that before it goes to you. So what are we doing in this particular topic? So the UNIDROIT Principles are an extensive set of rules, and I could say they govern international commercial contracts, but as you already know, there are soft law instruments, so they're not governing in the sense that a law governs. They're about 400 pages long. And the goal of the UNIDROIT Principles is to provide comprehensive guidance on a range of different elements of contracting across borders. We're going to compare that as we move forward with the Incoterms. So the Incoterms, in comparison, are really concise. They're a set of practical guidelines that define really the responsibilities and obligations of both buyers and sellers in international trade. They're essentially a shorthand code for who takes which elements of known risks. And when you think about what a contract is, contracts are largely allocating risks between the parties. Who takes the risk of the delivery not being on time? Who takes risk of the goods being damaged? And usually when we're negotiating those things, we're looking at who cares the most about those outcomes and who's in the best position to actually control them. So if you're driving the truck, it's often your responsibility to deliver the things on time. Now, as you know, and as I hope I convinced you last week, if you weren't already convinced, international commercial contracts are a fundamental element of globalization, and they're vital for facilitating global trade. It doesn't really matter where the parties are. There are economic, social, and significant cultural benefits as well as questions that arise when it comes to trading internationally. And we're going to start by thinking about contracts in a domestic sense. So all of you should have already completed at least Introduction to Contracts, probably both. You've got a sense of what it takes to make and to break a contract under Australian law. But when we've got contracts involving parties or activities that cross borders, we need to really consider carefully the legal frameworks that are involved in order to unpick what the contract means and what's going to happen, how it's going to be interpreted if and when, let's face it, when it happens a bit, things go wrong. So determining and understanding what the law is and what the principles are is fundamental to dealing internationally, but also for you as potential transaction lawyers. There will be lovers amongst you, not just fighters, of making decisions about how to guide your clients and how to write contracts when they span borders. So, little picture on the slide for those of you who are just following along to my voice. Have a quick look up and have a look at what is on the slide at the moment. It's a pretty common little optical illusion, and some of you might see a duck, some of you might see a rabbit, some of you might be able to swap between the two of them. I think this is a really good way of thinking about international contracts and the interplay between the laws. So what do I mean by this duck, rabbit, optical illusion concept? The best way I can think to describe it is how, let me tell you a story. very many years ago. It might have actually been in the last millennia when Japan was a significant power. And I was working in relation to some international trade contracts. We were moving goods from Australia to Japan. And there was, as is often the case in the negotiation of the contract, a discussion around, I think in that case it was around who would bear certain risks in relation to non-delivery. And anyway, we were moving forward, or I thought we were moving forward, and I said to the Japanese lawyer on the other side, I feel like we're heading in the same direction. And I was quite pleased with it. And the other lawyer said, yes, the very disappointed look on their face. We're heading in where it's almost as if we're in parallel. I'm thinking, why is he looking so distressed? And then I really, as I talked with him more, I understood when I say we're heading in the same direction, I'm thinking we're going to the same destination. We're going to meet at a point where actually the very precise way culturally that the Japanese lawyer was thinking, moving in parallel lines is we're both heading in a same direction, but we're never going to intersect. We need one of us at least to veer in a particular direction in order for us to intersect in the middle. So we can use the same words to mean very different things. So one of the issues that often comes up when we're writing international contracts, international business arrangements, is which language is going to prevail. Often the contracts are written, particularly significant contracts, and long-term contracts. So say, for example, I was involved at the earlier part of this millennia, this century, in a number of contracts for the building of power plants in China. And they were often created under what are called BOOT arrangements, so build, own, operate, transfer. And so essentially the whole range of the contract is over a period of time, could be as few as 10 years and as many as 25 years. The idea is that a power plant would be built and the technology and knowledge about operation would be transferred over time. So initially it would be owned by and revenues would be collected by the foreign party, but over the period of the contract it would move to the new party. Great, all makes great sense. So contracts would be written with English on one side and Chinese on the other. Now, I don't know if there are any Chinese readers, writers, speakers in this group yet, but any of you who have tried to get translation, translation doesn't work directly. Chinese can be a very contextual language. The characters work to convey a concept or a word, depending on which version of Chinese you're speaking, Mandarin, Cantonese, whatever it happens to be. The actual written character might be said completely differently. It's just written the same. It's not the kind of concept that we're necessarily familiar with when it comes to thinking about how the words work. Now, any of you who have worked through some of the cases in relation to contract law and the interpretation of cases will just see how difficult it can be to make sure that the wording in a contract is precise, concise, doesn't say anything that it shouldn't say, that the job of transactional lawyers is to predict as accurately as possible what it is a court might do if, heaven forbid, the deal goes sour, and make it as clear as possible for the parties what the rules of their game is when they start to play it. That private law that they've entered into between. So when you've got multiple languages involved, and this is only one of many problems, it can be really difficult to decide, well, what is the language of the contract? What is the law of the contract? And of course, there are plenty of other cultural issues that impact the way that we see or think about a particular issue. I asked you to look at the HSBC ad. It's an oldie but a goodie last week, to look at, just to have a bit of a laugh at some of those cultural differences and what they mean. But any of you who have travelled will know how things that are done or not done in a particular place will be completely different somewhere else. One of the examples I like to use is, have you ever been to a hawker's market in Singapore? In Singapore, one of the best restaurants in the world is a Michelin-starred hawker's vendor for crab, I think. And if you go there, you can take a day to line up to get your crab because it's so famous around the world. And so you might want to go off and do other things. How do people reserve their table? Well, in Australia, if you're in a food hall, which, let's face it, that's what a hawker's market is, you get up, you leave it, basically, you snooze, you lose. Like, if you leave the seat, somebody else is going to take it in a crowded space. Yet in Singapore, you'll see these empty tables all over the place with mobile phones or umbrellas or notepads on the table, basically reserving a spot, saying, I was here first, this is my spot. Now, I don't know about you, but I live close to Northland and shopping centre, heaven forbid that I go there, Knifelands as it's called around here from time to time. If I went to the food hall there and left my mobile phone, as soon as I turned my back, it would be gone. And yes, I might be stereotyping, but I'm telling you, it would be gone. I left my mobile phone on a table in Japan a couple of weeks ago, and one of the other customers raced out and looked around the station for me to give it back to me. Culturally, very, very different. So the way that we see the world, rabbit or duck, we can see it both ways when we're aware of each of these things. And so one of the real fundamental benefits of something like UNIDROIT is to help us contextualize and pull together a set of rules aimed at facilitating international trade. So let's get stuck in to UNIDROIT in particular. So this is the section I want to start dealing with UNIDROIT. Probably the point I should have made here, I'll go back to it, is Incoterms, a great way of thinking about Incoterms is as a shorthand, being really clear right from the beginning, whether we're talking about rabbits or talking about ducks, in the full knowledge that either might be applicable. So let's move on and talk about UNIDROIT. So Professor Roland Lowe said this, which I think is quite lovely, that the lex mercatoria, I never know how to say that word, I'm so sorry, is like a Yeti or a Loch Ness monster. Nobody's ever actually seen the lex, but maybe it might be useful at some different point. Now, the idea of the UNIDROIT is to consolidate and pull together that law of the merchants, these medieval set of rules that medieval traders from different areas kind of came up with themselves to facilitate effective trading. They were like a chamber of commerce, if you will, and just rather than wait for things to go wrong and the courts to decide what the rules were, they sat down to try and work out, well, what these rules should be. Now, clearly, I'm not imagining a whole lot of people coming together into some medieval town. There's a jester off to the side and some mead on the table, and they sit down and work it out. So sitting down is probably a bad expression. We can't point to a particular time and place. But over time, basically, it's a bit like backyard cricket. They agreed the rules. Whether or not they're written down, they're a combination of custom and the way that things get done. So the point of this was, when you've got traders from different countries, each of them speaking different languages, and they come together to trade, they need a common language or set of rules for that trading. And so the point of this was to pull together a set of principles and practices that would be recognized by everyone, ultimately recognized globally, and the purpose of it is to enable smoother and more predictable cross-border transactions. So contracting is the dominant method for international business, for facilitating international business, and it's central to the following forms of international business: sales of goods, sales of services, agency and distribution arrangements, franchising, licensing, technology transfer, joint ventures. At the core of the legal process for international commercial law is import and export transactions, moving goods or services from one place to another place. It's important to understand that this is a legal process. It's comprised of several discrete but interdependent contractual relationships. It's not just bilateral arrangements. I buy something, you're selling that something. When we're talking about crossing borders, we also have to move those things. We have to think about the way that domestic laws interact. So each of these contractual relationships might be governed by a different body of law or rules. And so ultimately, the UNIDROIT is a really good example of a voluntary or private law approach to dealing with the issues that arise because of the cross-border nature of the relationship. So they're soft law instruments. And as we go forward, next week we'll talk about the Vienna Convention, which for those states who have signed up to it are ultimately public and mandatory, so hard law principles. Of course, every set of rules has its own idiosyncratic operational effects, and we'll work into that a little bit more. I think it's also worth thinking here, and I mentioned this last week, so I don't want to dwell on it, is the difference between a civil and a common law approach to understanding what the law of contract is. I suspect it is easier for our civil law colleagues to get their heads around the idea of a written down law that addresses a particular circumstance and effectively is not at all influenced by the particular facts of a case, where we common lawyers who have spent our lives looking at the cases and looking at how the law has been applied in the past to understand how the law works now, despite the limitations of applications in the past being to specific sets of circumstances or fact that may or may not be as relevant to us now. So, as you know, UNIDROIT is an independent intergovernmental organisation which has the ambition, so its purpose is to harmonise international private law and craft international conventions, model laws and principles. And a really notable example of the work that UNIDROIT does of its application is the UNIDROIT Principles, so also referred to as the PIC, Principles of International Commercial Contracts. So in the introductory section, so part of the lecture videos, there's a very small video from Stephan Vogenaur, basically introducing what the principles are in the context of the release of a text with commentary, which again is quite a useful way of looking at how UNIDROIT works. In addition to UNIDROIT, the PIC, we also have other conventions that in turn make the hard law, and we're going to spend more time on those later. So what are we talking about here? So imagine two businesses, one from Australia, one from India, and they want to trade goods. They can shake hands on a deal. As we know, under Australian law, you don't need to have a document. If you have a document, then the parole evidence rule will work in such a way as to limit the ability or exclude the ability to bring in inconsistent information unless the written document is not a complete contract. So it will limit or exclude the ability to bring in verbal or oral evidence which is inconsistent with the written document unless the written document is not an entire contract in some way. So the way I've always explained that is contract is a verb and a noun. The act of contracting is a verb. The agreement to sell goods in Australia and to somebody in India to trade them in some way, that is the verb. But the written document is the contract. Use it as noun there. And one of the first questions that you might ask if you're writing the contract or if you're dealing with a dispute later, if it was only verbal, is under whose laws will this agreement be governed? And this is ultimately where our journey into the selection of substantive contract law begins and continues. We talked a bit about choice of law last week. Clearly, the first option is pretty straightforward. Choose the law of one state or another. If the Australian company insists on using Australian law and the Indian company prefers Indian law, well, we've got a battle on our hands and we've got to decide how we're going to resolve it. Each set of laws carries its own nuance, its own protections and risks for the parties involved. Clearly, there will be strategic reasons and strategic benefits for each of the parties in such a dispute in dealing with this. But let's say we reach an impasse and neither wants to do anything. What can we do? This is the second path, the UNIDROIT. The parties can agree to choose an internationally recognised set of guidelines and aim for a balanced framework that neither favours or disadvantages any one side based on their local laws. The benefits here is that it also provides a streamlining and, as a consequence, a cost-effective mechanism for resolving that dispute. So as I move on, we're going to explore the options in a little bit more detail and we'll think about why a business might prefer one option over the other. And I would be challenging you, particularly in the light of your upcoming assignment, to think about why commercially and strategically a party might choose one over the other, because I think that will be really relevant to you preparing this first assignment. Got a lovely QR code on the slide. The materials really refer to the 2010 update or the 2010 version of the UNIDROIT Principles. There's no real significant differences in the principles themselves. They're really both 2010 and 2016 are fairly minor updates, but knock yourselves out, ignore the 2010 version and use the current version wherever you can. And that lovely little QR code with a dinosaur on it will take you there. So let's recap. The purpose of the UNIDROIT Principles, is to govern essential but general elements of international contract law, contract formation and breach. It's really important to note that the general contract principles apply to all forms of international contract, not just the sale of goods. So what we're talking here can also apply in relation to transfers of trade or transfer of services or provision of services, online interactions. It could relate to professional services being delivered across borders, high finance, a range of different things. And the aspects covered include all aspects of contract law, including offer, acceptance, formation issues, as well as performance and breach. You can choose to have it apply, or a court can also use it to interpret the contract when another law applies. So its ambition is to be neutral, universal, and complete. And its function is to facilitate international trade. Now, remember that when we're dealing with the private laws that people make when they're contracting with each other, their purpose is to engage in trade between the two of them, not necessarily to move the path forward for everybody else, where this set of rules has been designed to try and facilitate or improve trade between nations and across borders. So our focus is going to be on UNIDROIT as a source of international contract law. We're going to look at the principles as a source of law and compare them as with Australian domestic contract law. So we've got case law in the Australian sense versus UNIDROIT, a rules-based regime. And then secondly, it's generally required, it's important to know that it's generally required that in order for the parties to adopt UNIDROIT as their method of going forward, as their choice of law, they need to explicitly state this in a contract. But that doesn't mean that a court, once it's been decided that a court has jurisdiction to hear something, it may well use the UNIDROIT principles to augment and understand the way that the laws of the domestic state apply as well. So the person who can explain this better than me is Stephan Vogenaur. I think I said Simon Vogenaur before, that's embarrassing. And as I mentioned, basically you should have already listened to him, but just in case you skipped forward, I love that he calls it a bit like Esperanto. Esperanto being, the idea of a universal language that everybody can understand. Don't know about you, but my Esperanto is pretty weak. Not even sure if it's available as a language on Duolingo. Yes, the other note that I have here is actually he talks about the PIC. He talks about it as the PIC, so the Principles of International Commercial Contracts. It's a terrible acronym. So I must admit I tend to say UNIDROIT, or as I've said before, UNIDROIT. So I just wanted to point out that acronym, Principles of International Commercial Contract, that's what he's talking about when he talks about the PIC. Same thing, same, and not different. It's worth actually just spending a minute actually thinking about what UNIDROIT is. It's basically one of the reasons that the PIC, talking about it as a PIC, is probably technically more accurate, is UNIDROIT is an organisation. It was established close to 100 years ago. It's an intergovernmental kind of association. I think of it like a chamber of commerce, to be perfectly frank. As at the end of 2023, or as at right now, there were 65 member states. Interestingly, Mongolia and Singapore are the two most recent entrants. They joined last year. And they frequently engage international law experts to do research, drafting, and then they basically ask the members to endorse the proposals that they put together. I am not going to hurt your ears with my terrible French, but basically UNIDROIT is it's not an acronym, but it's a consolidation, a kind of shorthand, a nickname, if you like, for the name of the international organization, which, while it is based in Rome, basically has a French name. And what's important here is purpose. And I know I've mentioned this a few times, but I just want to reiterate it. The purpose is to study needs and methods for modernizing, harmonizing, and coordinating private, and in particular commercial law, as between states and groups of states, and to formulate uniform law instruments, principles, and rules to achieve those objectives. So keep that in mind as you work through these things. The principles themselves, the intention is that they're a kind of codification of the original lex mercatoria, the lex, let's call it the lex. So it's a codification or a consolidation of international contract rules. It's derived from the lex, it's derived from custom, and of course national legal principles. Its purpose is to be, as much as it can, to reflect best practice. So initially it was meant to be a guide relating to formation, contract substance, and the choice of law, so the resolution, but over time it has become so much more. It started as this guide, and work started on it as early as 1980, but the first version of it, which is substantially it has continued on since, was issued in 1994. There was a small update in 2010, and the current version, the 2016 version, also is what continues now. Now, the updates are quite small, and they particularly relate to the concept of long-term contracts, which were introduced into UNIDROIT in 2010. So I know I keep talking about the purpose, but it is worth actually having a look at, just as you would if you were thinking about what is the purpose of a piece of legislation, having a look at the preamble of the rules themselves. The image I have, the words on the slide, come from the 2016 version, and they state that the principles set forth general rules for international commercial contracts. They shall be applied when the parties have agreed their contract govern them. So little asterisks there, and when you look at the long form version with the commentary attached to it, the 400 pages, you will see that it also talks about if there is no explicit statement, when courts might actually choose to use them to assist them with interpretation. They may also be applied when parties have agreed their contract be governed by the general principles of law of the lex mercatoria or similar. They may be applied when the parties haven't chosen any law, so the court might decide to use them when it's just not clear what the choice would or should have been. They can be used to interpret or supplement international uniform law instruments. They can be used to interpret or supplement domestic law, and they can serve as a model for national and international legislators. So clearly, there's 400 pages here. I don't expect you to read them, much less memorize them, to be perfectly frank. But what is really important here is that you have a look and think about the ways that you could use these to inform the way that you guide your clients or write agreements, whether or not the agreement is going to be governed explicitly by UNIDROIT or otherwise. It's really important, to be aware of the principles themselves, and to ultimately, as a commercial lawyer, to develop a mindset that considers relevant aspects of UNIDROIT when you're engaging in commercial negotiations. So I've listed from chapter 1, I think it's not too big an ask to ask you to actually wander through chapter 1 and think about what it means. I'm not going to talk about each of the articles, but there are a couple that I want to point out. In particular, Article 1.2. Let's see if I can draw on my slide here. Yes, it looks like I can. So 1.2 here. Why this is important is just to remember that, like the common law principle of contracts being a verb and a noun, the noun isn't always important. There is no requirement as to form. A contract can be made verbally, it can be on paper, it can be on a USB, it can be made over the phone, it can be an exchange of emails, it can be a range of different things that lead to the meeting of the minds and the making of an agreement. There is no specific form required. Another one that I think is really worth us paying attention to is have a good look at Article 1.7, good faith and fair dealing. You cannot exclude these if you've adopted UNIDROIT as your terms. Now, for those of you who've studied contract law, you will, well, which should be all of you, you will be aware that this is not a settled principle under Australian common law. An obligation to act in good faith is not a standard position for us. So we'll come back to this in a minute, but I just wanted to point out at this stage that it's there. In relation to formation, I think one of the things that's going to be really important, again, have a look and read your textbook about the details. One that I'd really like to point out to you is the rules in relation to rejection. So an offer will be rejected when the rejection reaches the offeror. So if there is, now when we think about international trade, particularly historically, less of an issue now, there could be huge gaps in time for information, basically information exchanges. Many of you will have struggled with the postal acceptance rule when you were learning about contracts the first time. And it always does my head in that we have to teach it, because in real terms, it's rarely that people do deals over post anymore. And clearly instantaneous communications are an exception to that rule. But it is worth noting that if rejection of an offer, basically the timing of that is deemed to be the time when the rejection reaches the offeror, that's quite different from the postal rule, which actually talks about communications effectively being deemed to have been made when they are sent. Frankly, I think this is a much more sensible rule in many ways. It puts the onus on the person communicating the important information, the acceptance or the rejection, puts the onus on them to communicate it immediately. And so it sort of passes the risk to the right person, the person taking action. But also we have this kind of different approach, and this comes out of the civil versus common law understanding. Chapter 3 deals with validity. Now, again, I haven't got all of the rules up here, but I've highlighted the ones that I think are most important for you to have a look at. One of the things that I think is really worth thinking about is the impossibility of completing a contract doesn't negate the contract under the UNIDROIT principles. And this is clearly quite different from our understanding of the way the force majeure rules might work under a contract that is purely domestic under Australian common law, and could well be a trick for young players. I'd be really interested, this might be one that you might want to have a look at and think about over, particularly during the heady days of the pandemic, particularly second half of 2020, first half of 2021, where there were a whole lot of reasons why goods were not moving or services couldn't be performed in the way that was originally contemplated under a contract, and what the implications of these rules were, and the extent to which there were fights over them. Chapter 4 deals with interpretation. How do we interpret a contract? And I think what's important here is to really make sure that you understand these particular rules. It works slightly differently because we look for, firstly, what the parties actually agreed to, so actual intention, as opposed to an interpretation that goes straight to the second principle, what would a reasonable person understand is being meant by that particular clause. And even when we do look at that sort of second level, if we can't ascertain what the parties actually agreed to, what their actual intention was, then we can go to the question of what a reasonable person would understand had been meant by the clause. But a reasonable person is a reasonable person in the same situation, the same type of transaction. It's also worth noting here that Chapter 4 requires that the terms are read in the context of the entire agreement, that they're not read in isolation. Chapter 5 deals with the content of the contract. What's really interesting here is this duty to cooperate in particular. Again, that's something that is not, it's really not something that is embedded into the Australian contract law unless the parties have specifically agreed that they will cooperate with each other in a particular area. So think about why we have these kind of provisions that are quite different from the common law. In particular, so duty to cooperate and the duty to use best efforts. Many of you will be painfully aware of how many cases under the common law and in the Australian context have explored the idea of best efforts, most reasonable efforts, those kind of provisions, and come to an understanding that the whole thing is just too hard to get your head around, and you just want to really avoid the words best efforts in particular when you're writing a contract. But when we think about, again, if we go back to the purpose of UNIDROIT, then we're basically reminded that the purpose is to facilitate international trade. So we're looking at a best practice approach, and a best practice approach would see the parties basically each doing their best to facilitate the contract. And effectively the underlying thought here is we want international trade to go well, which is quite different from the private law ambitions of two parties just creating contract between themselves, where they don't care necessarily about the deal as a whole and what the impact is on other people around them. Each party just wants to get the best deal for themselves, at risk of significant oversimplification, that is. Chapter 6 deals with performance of the contract. Really interesting. The rules in relation to time are different. It specifies rules in relation to performance and specifies rules in relation to payment. Now, clearly there's a lot more in Chapter 6 than those, but they are the ones that I would like you to focus on first and think about the similarities and different. And this is something that we will probably talk about in the tute. I'm just putting it on the screen there for those of you who are going fast, just so you are well prepared. In order to get an understanding of how the rules work, we're common lawyers, right? We feel comfortable when we see examples. Now, while it's not precedent as such, examples of how they've worked in the past are incredibly useful and informative to us. Unilex is a really great database. It suffers a little bit from a lack of updating in recent times, but it's a really great compendium of international law around the UNIDROIT and the Vienna Convention that we'll be talking about next time. When you go in, you will basically see, let's see if I can, oh no, it's not going to let me do it because I've got the pen on. Basically, if you click on the slide, you'll have a link. Otherwise, just do that thing you do with your phones to go for it, or just Google Unilex, UNILEX. And the first page that will come up, it basically asks you which you're interested in, UNIDROIT or the Vienna Convention. And then when you go in, you're able to search. So you're able to look at the provision and see what examples of disputes, including arbitrations, there have been. You can then also search by key term. You can search by country. You can look for patterns. It's a really nice database to use. I really quite like it. My tea is getting cold. So the next question that we want to focus on is the relationship between UNIDROIT and domestic commercial law. So where are the gaps? How does UNIDROIT deal with domestic legal systems and domestic courts? It's worth actually thinking that the principles are often used by domestic courts as general principles of international law. So we think of them as kind of gap fillers. So a few different issues, and we'll talk about some of them in the tutorial, but I've raised this one already, good faith and fair dealing, Article 1.7. This is not a settled issue in Australia, and I'd like for you to think about whether it's a good doctrine or not. Should we be requiring parties to act in good faith? Now, clearly there are some elements of statute that come close to that. So when we think about the competition and consumer law, or we think about, actually it's in the ACL now, the Australian Consumer Law, thou shalt not in trade or commerce mislead or deceive people. And we have an unfair contract law. So we have statutory provisions that impact the way that contracts might be enforced when it comes particularly to unequal commercial relationships. But do we need something higher again? Should we be following this UNIDROIT method of the good faith and fair dealing? Also, as transactional lawyers, when you're advising your clients and you're seeing provisions in international contracts, think about the ways that UNIDROIT might impact the reading of those provisions. Another one that I want to point out is consideration. Consideration, the principles don't actually require consideration for a contract to be concluded. Now, consideration is under the common law a significant element. No consideration, no contract. Remember, past consideration is not good consideration. Consideration is the price of the promise. Usually the promise to deliver goods or services is accompanied by a promise to pay for those goods or services. So the consideration is actually the promise to pay, and payment will follow. Under UNIDROIT, if those are the relevant rules, it may well be that the price might not be agreed, but will still be enforceable subsequently, even though there was no clear promise at the time that a contract was concluded. What do you think about this? Does this make sense to you? Is this a good idea? Do we really need consideration in domestic law? Or what does this mean for you understanding the way you're going to talk about consideration with clients in a transactional sense? Altering and preserving contracts for hardships, articles, so this is chapter 6, article 2.1 to 2.3. Really interesting here. The principles show a marked preference for keeping contracts alive. Now, again, in domestic contract law, we, particularly interpretation cases, we often hear judges talking about how we need to have a sensible reading. In a choice between something that doesn't make any sense and a sensible or reasonable reading of the contract, we go with the most sensible reading. But UNIDROIT provides for a circumstance where a party is unable to perform contractual duties as a consequence of events that fundamentally alter the equilibrium of the contract. They can request a change to the contract by the court, something that courts are not keen to do under Australian common law. Courts in Australia, just generally, courts cannot rewrite contracts to deal with changing circumstances in Australia. Either the original duties remain or the contract comes to an end. I think this is something you're already familiar with. So what do you think? Particularly think about what happened over the last couple of years with the pandemic. Should Australian law adopt a doctrine of hardship? If circumstances change after you agree to do something and it becomes particularly difficult for you to do them, should the contract be alterable? Chapter 7, Article 7.1.4, which deals with non-performance. So here the principles show a marked preference for keeping the contracts alive. I mentioned that just not just a minute ago, and they allow for non-performances to be cured. Non-performance can be cured by extending the time for performance when the conditions are met. Now, clearly this is not the law in Australia, and often we are going to great lengths to be really clear about whether time is of the essence or not. Non-performance of a contractual duty constitutes a breach of contract, which can allow for termination, particularly where time is of the essence, so where it is a condition as opposed to a warranty within the body of the contract. What do you think about this? Is this sensible? What does this mean? And think about the context over which this might have been developed and how we might have seen it enacted over recent times. Another key difference, and the last one I'm going to really point out, and the devil is in the detail here. There may well be significantly more detail that you find if you wish to look at it, is think about the battle of the forms. So the principles here adopt what we refer to as a knockout doctrine. Courts will hold that a contract has been concluded and that its terms are those that have been agreed by the parties and any of the parties' standard terms that overlap. So essentially, UNIDROIT enables courts to uphold contracts even when the parties performing it disagree on what the terms are. So technically the battle of the forms, you will remember, is when we've got a purchase order that sets out certain terms, and usually it's an invoice or standard trading terms that are different, and then usually the courts need to look at, well, what is the relationship in the party, who was the offeror, who was the acceptor, and what have they actually done over time. So in Australia, we tend to think about it as the last shot doctrine. So the final document that's put forward prior to the parties actually engaging in contract is the last version of the contract, and it's considered to be the offer that the other party has accepted. What do you think? How in practice does this work, and what do you think is better, worse? And what does this mean for you as transaction lawyers advising your clients? And basically what we're going to do is we're going to think about in the tube, we're going to talk quite a bit about what your assessment of the principles is, which ones you think we should be adopting, where you would be recommending your clients be more careful. So I'm a big fan of the Gilmore Girls. I love a pros and cons list. Oops, sorry, I'm just going to work through here. So pros, the merits. UNIDROIT is flexible and it provides for autonomy. It provides parties with significant flexibility to structure their contracts as they see fit, promoting autonomy in commercial transactions. Again, you might have, this can be you can look at this as I want to use right or left wing approach, but I'm really talking about a kind of, we can talk about a kind of Western capitalist approach versus a socialist approach to a certain extent. And I am really oversimplifying when I use this as a lens to think about it through. But we tend in a Western capitalist sense to value autonomy to contract. And there is plenty of research, and you can see yourself that countries with stable and open markets, where they have a stable legal regime that consistently enforces documents, consistently enforces contracts, are more likely to have economic stability and economic success than closed economies with significant, often obtuse or opaque laws or rules and inconsistent dealings with those laws. So we tend to, and one of the reasons that modern contract law in a common law sense has evolved the way it has is partly to promote that flexibility and autonomy. Uniformity and predictability. By providing a harmonised set of rules, the principles contribute to reducing legal diversity and uncertainty in international trade. Uniformity helps businesses by making outcomes predictable, facilitating smoother transactions, facilitating efficient and cost-effective actions. It's also really useful as a gap-filling and interpretive aid. The UNIDROIT principles serve as a supplementary tool to domestic laws and international agreements, helping to fill gaps and interpret terms in the absence of parties' explicit agreements or specific provisions under applicable law. It provides a neutral and a balanced framework. It's not biased towards any national legal system, which can be particularly advantageous in international negotiations, providing a balanced ground for contract terms. And it's focused on enhanced fairness and equitable treatment. The terms themselves emphasise fairness, good faith, fair dealing in commercial transactions, which in turn promotes equitable treatment of the parties. This is really useful in balancing the interests of weaker parties against more dominant counterparts. Unless, of course, you're the dominant counterpart, right? So what are the demerits? What are the cons? Voluntary nature and the lack of binding force. These are soft law principles. This is a significant limitation, is they're not binding unless they're expressly chosen by the parties. In other words, the parties have entwined them in the private law that they've created for their contract themselves. The voluntary adoption might limit their applicability and enforcement in jurisdictions that don't recognise them as binding, which is everywhere. Interpretation and application variability. Because they are general, the principles can be subject to varying interpretations and applications by different courts, different arbiters, which can lead to potentially inconsistent outcomes. This is where Unilex is pretty helpful to you. Of course, there is the potential for conflict with domestic laws. There can be instances in which the principles conflict with mandatory provisions of domestic law, leading to complexities and legal uncertainties in their application and their enforcement. Lack of awareness and understanding. Despite all the benefits, there's still a lack of awareness and understanding of the UNIDROIT principles amongst business people in particular, and even amongst legal practitioners. This can hinder the broader adoption and their effective use. Also, they're limited in scope. So the principles primarily address the issues of contract law. So there is a risk that they don't adequately cover other areas of law that might be relevant to international commercial transactions. For example, intellectual property rights, specific regulatory compliance issue, occupational health and safety, all things that we will explore further as we move through the course. So, personally, I think they are a valuable tool for international commercial transactions. They promote uniformity, flexibility, and fairness. But their effectiveness can be influenced by factors including whether the parties choose to use them, the way they're interpreted, and the legal context in which they're going to be applied. So if you are drafting or negotiating international commercial contracts, it's essential to consider the pros and cons as part of the activity of deciding whether or not you want to incorporate them into your contractual framework. So that's all I want to say about UNIDROIT for now, and I am going to continue in a separate video talking about the Incoterms. See you there.